Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 129. Apologies, suffering with a cold at the moment, or to the after effects of it, so if I sound like I'm speaking with a clothes peg over my nose, bear with me this time. Anyway, we have 3 cases, of course, this week. Some weeks we have cases that push the boundaries of what we understand employers' obligations to be, or employees' duties to be. This week it's different. We have 3 cases which probably by themselves do not tell us anything we should not already know. However, they are a useful reminder of points that can come up fairly regularly in some cases, which is why I wanted to put them in the podcast. Finally, as I think I've mentioned in the past, we've no idea who listens to the podcast episode, so one listener got in touch for various reasons. I was going to give them a shout out, first names only, of course, at the end of the episode. So do get in touch if you listen, because I'm genuinely interested to hear from you. No travelling salesperson will call at your place of residence, and nor will we sell your data on the dark web. Promise. Oh, and I've got a podcast recommendation for you at the end of this as well. As always, you can access the podcast via iTunes. It's on the Mayor Brown website, YouTube, the Twitter feed, where the handle is Nicholas ROBER11, and that's where we put out links to all the cases as well. So first up, Ruiz Coñero and Ferosa Servicios Auxiliares, and I do apologise to any Spaniards listening. Spanish case to do with sickness absence, which made its way up to the European Court. Under Spanish employment law, employers are permitted to dismiss employees who have intermittent absences. So, for example, if you have 20% of your working hours off in any 2 consecutive months, or 5% of your working hours off in any 12 months, then the employer is entitled to dismiss you. Of course, this has to fit alongside the rules on disability discrimination as stated in the Equal Treatment Directive. And this case arose where an individual who otherwise had perfect service went through the trigger points and was dismissed. He argued that the Spanish law on dismissal was incompatible with the Equal Treatment Directive because the law discriminated against those with disabilities who were much more likely to have intermittent absences than non-disabled employees. As I say, the case went all the way up to the European Court of Justice, and the European Court had little difficulty in deciding that the legislation was indirectly discriminatory, potentially. The Court accepted it was not direct discrimination against disabled employees because there was an ostensibly neutral criterion that was applied to all employees, and this criterion, sickness absence, was not inseparably linked to disability. However, they accepted that a worker with a disability was in principle more exposed to the risk of being dismissed under those provisions of the Spanish law than a non-disabled employee. Therefore, he or she was liable to be put at a disadvantage, and that engaged the indirect discrimination rules. Spanish government pointed out there were certain provisions that mitigated this risk. For example, individuals who were off continuously for that period were not liable to be dismissed. It was the intermittent absences that rendered them liable to be dismissed. Secondly, matters such as cancer or serious illness, which caused intermittent absence where the individual was taking time off for medical treatment, also did not legitimise dismissal. However, this did not change the fact that the European Court decided that the Spanish legislation was indirectly discriminatory. The European Court said that it was up to the national court to decide whether or not the indirectly discriminatory impact had been shown to be justified. The Spanish government, for example, said that part of the rationale for the legislation was to increase productivity and efficiency at work. It was to avoid absenteeism and reduce costs for employers. And the court accepted that combating absenteeism could be a legitimate aim. But it was for the national court to decide whether or not Spanish legislation was justified. Well, the reason I wanted to mention this case is it's quite common for employers to look to dismiss employees when they reach a particular level of sickness absence. And it's no great surprise to find this is something which is capable of triggering a disability discrimination claim where the individual themselves is disabled. Now here, of course, the Spanish government is entitled to a broad measure of discretion in the eyes of the European Court because it's implementing a social policy designed to balance the interests of disabled workers with the interests of employers. A private employer, of course, is not going to get the same measure of discretion. Therefore, it will have to work harder to show that a policy of dismissing individuals after a particular period of absence is justified. Clearly there are circumstances where it will be, and to that extent this case really reminds employers to think twice about pushing ahead with a dismissal just because it is in their procedural rules. In the UK, for example, we had Griffiths and the Secretary of State for Work and Pensions, where the Court of Appeal accepted that the disability discrimination legislation was engaged, where the employee was dismissed on the basis they were under a final written warning for a sickness-related absence. The employee wanted to argue that because the absence was disability-related, a reasonable adjustment should have been made, i.e. disregarding the final warning. The Court of Appeal accepted that, in principle, disciplinary sanctions for sickness absence could be covered by the duty to make reasonable adjustments. So that's the case of Ruiz Corneiro and Feroza Servicios Auxiliares, and I don't think I said that any better the second time round. Next up, Feltham Management Limited and Jane Feltham. The second case is an EAT case in connection with unfair dismissal and discrimination. It shows the difficulties that can arise for the parties where the termination of employment is disputed, and one or other party is denying that a contract was terminated, and if it was, there is a dispute as to when it was terminated. The facts make for particularly sad reading if you go through the full report, but in essence, Jane Feltham, who worked for the company, fell out with her siblings, who also owned and worked for the company. Up until the falling out, she had been the office manager. There was an argument in August 2013, between the siblings, and the claimant left work on that day very upset. She remained a director, continued her benefits provided to her, such as company car and credit card, but the company stopped paying her salary. She then wrote offering a degree of reconciliation, which was not acceptable to her siblings. That was June 2014. There was no reply to that letter, the June 2014 one, until October 2014, when the company replied, let's call that first letter, saying that she was taken to have resigned in August 2013 and therefore she would not be permitted back to work. The first letter, also stated that at some point in the future her benefits, credit card, etc. would also be cancelled. Claimant, not entirely surprisingly, instructed lawyers, and the company then, after correspondence, wrote another letter. Guess what? We'll call that the second letter. It said the same thing. This was in December 2014, their second letter, and said that she was off payroll and a P45 had now been issued. They continued to assert the August 2013 date. Claimant took the second letter as the letter of dismissal, December 2014, started unfair dismissal proceedings, and the claimant succeeded completely in front of the Employment Tribunal. The Employment Tribunal found that the dismissal date and the effective date of termination was December 2014, i.e. off the back of the second of the two letters the company had sent. This was important because it meant that her statutory claims were in time. She won her dismissal claim, her discrimination claim, and her claim for unpaid wages because she'd been prevented from attending work from September 2013 up until December 2014, when the contract ended. The company appealed. Well, the Employment Tribunal had to start by considering when the contract was terminated, and that's a common law question at this point. Well, following the guidance given in SocGen and Gies, the EAT accepted that for a contract to be ended, the parties should be notified, or the other party should be notified in clear and unambiguous terms that the right to end the contract was being exercised. Here, the letter written in October 2014 asserted that the claimant had walked out and effectively resigned in 2013, and that was not such a clear letter. It was evidently mistaken. She hadn't effectively resigned in 2013. And although the letter of October 2014 was a repudiatory breach of contract, the claimant did not accept it and was not under any obligation to accept it. Indeed, the court commented that they thought the letter of December 2014, too, the second letter, was not a dismissal letter. But since it had been accepted as a dismissal letter by the claimant, the point did not need to be decided. The court pointed out, of course, that the effective date of termination of the contract could potentially be a different date from the date on which the contract ended for common law purposes. Here, however, again, the court accepted that the words or conduct had, in their context, to amount to a plain and unambiguous termination by the employer. Informing the employee that no salary will be payable, which is what the first letter said, did not necessarily convey that the employer was terminating the contract at that point. There could be other equally good reasons for withholding the salary, e.g. if the employee was ill. In the circumstances, the EAT upheld the Employment Tribunal's finding that the EDT, the effective date of termination, was also December 2014 and the claimant's claims were in time. The other matters raised by the company in the appeal were rejected too, apart from the direct discrimination claim. That was centred on the fact that the claimant's pay had stopped when she was away from work, but an alleged comparator's pay had been continued. The EAT felt that matter needed reconsideration by the tribunal. I thought this was a useful case to put in the podcast because it relates to not that unusual situation, legally speaking. The facts were, as I say, particularly sad. One party says the contract was terminated on a particular date and writes letters to that effect, while the other party, partly to preserve its position, denies that such a termination took place or disputes the date of termination if it accepts that the contract has ended. Here, and with the undoubted benefit of hindsight, if the company had written to her in October 2014 stating the contract was at an end unequivocally, and had said it maintained the position that she had been the one to end it in August 2013 when she walked out, this would have been effective to at least end the contract in October 2014. The company would have made it clear that if the contract was not ended in August 2013, it was now being ended. If nothing else in this case, if the claimant had then taken time to issue proceedings, she might have been out of time, and of course remember that she won her wages claim, her wages deduction claim. So the company ended up paying her salary from August 2013 through until December 2014 without her actually working. I think it's always worth considering. Make sure that if there's a fallback, to make sure that the letter you're sending actually constitutes notice of termination itself, even if that is stated not to be the primary position of the employer. I think it would be very difficult in these circumstances for the claimant to have argued that because the company was mistaken in its interpretation of events in August 2013, a clear and unambiguous notice in a letter of August 2014 saying, if we're wrong about that, this letter is ending your contract. I don't think there's a basis for challenging the validity of the notice of termination if it's given as a backup rather than as the company's primary position. So I think the only other point to make about that is I'd like to thank the members of my team for pointing out that the company logo was FML, a term I hadn't come across before, but which I am now cognizant of. So that's the case of Felton Management Limited and Jane Felton. Third and final case, Tynan Weir Passenger Transport Executive and Anderson and others. This case is addressed at a point which surprisingly has been unclear up to this point in connection with Part 2 of the Employment Rights Act 1996. Facts, very simple. Claimant was a member of what were known as Red Book staff. A dispute arose between the employees, the union and the employer as to whether or not individuals had been underpaid for a period of time. In order to determine that, because it was disputed by the employer, it was going to be necessary for the court to construe, or the tribunal I should say, to construe and interpret the provisions of the relevant contractual terms in relation to a shift allowance. Surprisingly, it was not clear prior to this case whether, under Part 2 of the Employment Rights Act, which I'll explain in a moment, a tribunal was entitled to interpret a contract in order to determine a claim for underpayment or non-payment of wages. The legal context in which this point arises is that there were two cases of the AT in 2017, Agarwal and Cardiff University and another, and Weatherilt and Cathay Pacific Airways Limited, which took opposite positions on this question. Agarwal case took the view that the Employment Tribunal was not entitled to construe documents, and it was limited to applying the terms of the contract, but not interpreting them in deciding deduction from wages cases. This was based on comments by the Court of Appeal in Southern Cross and Perkins and others. I'll come back to that. The Weatherilt case took the alternative view and considered an employment tribunal could interpret provisions of the contract, and to that extent, as I say, it disagreed with Agarwal. Here, the AT, in a lengthy judgment, went through all various authorities. The Southern Cross case, that had been relied on heavily in Agarwal, is clear that the tribunal is limited to identifying the terms of the contract and not interpreting those terms, because they said interpreting the terms was a matter for the civil courts. However, the EAT pointed out, in this case, the Tynan Weir case, that Southern Cross related to Part 1 of the Employment Rights Act. Part 1 requires the employer, broadly speaking, to give a written statement of terms and conditions. It is possible for an employee to go to the tribunal and say that the statement is wrong, and the tribunal can correct it. But under Part 1, it is not open to an employment tribunal, according to Southern Cross, to add in terms which should have been agreed, or, according to the Court of Appeal, to interpret the terms which it finds were agreed. Its powers are, and this is my terms, not the Court of Appeal's terms, purely declaratory. However, in this case, the EAT felt that this logic did not apply to Part 2 dealing with the alleged unlawful deduction from wages. Therefore, the EAT came down heavily in favour of the Weatherilt case, and that Agarwal was wrongly decided. Standing back from the case, this all seems so clear and obvious, it's difficult to imagine it's taken 3 EAT decisions to get to this point. I think there's no logical basis for saying that an employment tribunal, in relation to unlawful deduction from wages claims, is precluded from deciding what the contract means, when it is deciding whether there's been an underpayment. It does mean for employers that the unlawful deduction provisions have been strengthened, because there will be more cases that can be brought under those provisions than previously brought, because employees are not going to have to go off to the county court if there is a question of interpretation in relation of a contract in relation to their claim. So that's the case of Tynan Weir, Passenger Transport Executive, and Anderson and others. So, thank you very much for listening as always. I do hope you find these cases useful. I said I'd mention one of the listeners who'd written in, so a shout out to Nikos in Cyprus, who wrote in with a question on something I've been saying. I said I'd mention a podcast too, didn't I? For those of you who've been with us for a while, you'll remember that a couple of years ago I was listening to a podcast called Serial and raved about it, and I think a number of other people wrote in and said yes, they too had found the podcast to be absolutely enthralling. If you enjoyed that, can I strongly recommend A Very Fatal Murder from Onion Public Radio, which does what the Onion does best, which is completely take the mickey out of the podcast, the criminal podcast series, Serial in particular, but just generally it's absolutely spot on, perfect, down to the adverts, the plugs for pledges, the background music, the whole thing just works a treat, and in each episode is only about 10 minutes long, so it doesn't outstay its welcome. So, Very Fatal Murder, available from all good podcast retailers. So, until the next podcast, stay safe, and I'll look forward to doing the next podcast in a couple of weeks' time. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.